Series. I'm Kanisha Cunningham, and today we have Cheryl Kane Piasecki, who will be discussing the rules surrounding gifts between employees. But before we begin, I have a couple of administrative announcements. Next week for our Advanced Practitioner Series, we will discuss recently released OGE guidance. We will discuss the application of the Employee Benefit Plan exemption, specific questions that OGE has recently received regarding how the gift rules apply to certain events, and guidance on what types of prepaid gift cards are considered to be cash equivalent. In addition, we will also have at the end of this month a post-employment MOOC. So look for those announcements to be released in the next few days. And for those folks that's on the Google Hangouts, if you would like to ask a question, you can do so by typing your question in the right side of the screen in the panel window. And with that, I'll turn it over to Cheryl.
Thanks, Kanisha, very much. Welcome, everybody. I'm pleased to be able to deliver to you the first, I think ever, perhaps, a presentation that OGE has done on gifts between employees. I saw there was a rather robust registration on Max, and that was sort of exciting. And I think it's not because this provision is particularly onerous or difficult. I think it's just because OGE has not really talked to you all about it too much. And I think the gifts between employees section sometimes, I don't want to say it gives ethics officials heartburn, but I think it's one of the sections that it's not quite consonant with the rest of the standards of conduct because it really is an internal looking set of rules. It's really governing what federal employees may do among themselves as opposed to, vis-a-vis the private sector. And to that extent, it's sort of a set of housekeeping type of provisions. That being what it may, I think we all have to be as aware of these and as on top of these as we are of any other part of the standards, notwithstanding that they're just a little different than the rest of the standards of conduct. So what I'd like everybody to do, if you can, for those of you who are on the phone, I will try to let you know as I'm advancing the slides because I know that you're just hearing me talk. And for those of you on the Hangout, you'll obviously see as I process through them. But if everybody could get out the Subpart C of the Standards of Conduct, we're going to start with a little bit of an orientation to the actual restrictions themselves because I think that the way that they're written, it's not intuitively obvious how these restrictions apply. And so I'd like to sort of break them down for you into two sort of discrete pieces. So if we could get our regs out, and if you can follow along with me in the slide deck, I've advanced to the second slide. The gifts between employees provisions are really broken down into two discrete pieces. The first part of the restrictions deals with, and it's entitled, gifts to superiors. So the first part of it in 2635.302A is focusing on giving, the giving part of the gifts between employees provisions. And so it's dealing with, those times when you want to congratulate your boss or tell your boss how much you appreciate them. And what the restriction says is, and I'm on slide 3 now, folks, an employee may not directly or indirectly give a gift to or make a donation toward a gift for an official superior. So clearly here we're talking about you individually as an employee. If you want to directly decide to give a gift to your official superior, it's addressing that. But it's also addressing whether or not you are permitted to actually donate to a collection for a gift to your official superior. But it doesn't stop there. The giving restrictions don't stop there. They also address themselves to soliciting others for contributions toward a gift. And that comes in 302A2. And for folks on the phone, I'm at slide 4. An employee may not solicit a contribution from another employee for a gift to either his own or the other employee's official superior. So now we're talking about not only are we restricting your ability individually to donate, we're also restricting your ability to pass the hat and ask others to donate, whether or not it's for your own superior or for anybody else's official superior. So that's the first set of restrictions. And it seems interesting because where it's putting the prohibition, it's putting the prohibition on the subordinate employee. And it's not until you get to the second set of prohibitions where we actually start talking about the superiors, what restrictions apply to a superior actually receiving a gift from a subordinate. And if we look at the language in this one, it's actually a little more involved than you might think. And I'm on slide 6 now. Generally speaking, it's saying you can't accept directly or indirectly accept a gift from an employee, notice, receiving less pay. So now we've moved from this notion of superior subordinate, which I think everybody kind of gets. We get the sort of, it's an inherently coercive relationship between a superior and a subordinate. And so we want to limit the ability of that sort of authority and power to be able to be perhaps misused in a way that's coercive or that makes subordinates feel like they have to do these things. But this isn't just dealing with superiors and subordinates. This is reaching to employees who receive less pay. Now that gets tempered a little bit because it says you can't do that unless, and the unless provision says the two employees are not in a subordinate official superior relationship. So this exception, if you want to say, or this carve out, is pretty much recognizing, okay, so if it's not a superior subordinate relationship, we're not as worried, we're not as concerned. And there's a personal relationship between the two employees that would justify the gift. So this is obviously trying to recognize that not every time there could be a gift exchange between a higher and lower paid employee is there necessarily something that we should be concerned about, and neither should we necessarily prohibit it. Now, one thing I wanted to point out here, because I think we do get some questions about this, is how personal does the personal relationship have to be in order to be able to sort of avail yourself of this carve-out? And OGE's position on this has been, for the most part, I think a little less restrictive, if you will, than we have like in the personal relationship exception in the gifts from outside sources. In gifts between employees, we have said that you don't have to necessarily be BFFs, and for gifts between employees, you don't have to be best friends, and you don't even necessarily have to socialize outside of the office. That for the gifts between employees provisions, I mean, I think it's just a notion if there's a general professional collegiality, that's sufficient to allow you to avail yourself of this carve out when there's no superior subordinate relationship. So you go into the next slide, which is slide 11. Now, I know that provision, I think, has always puzzled me a bit, and I think it puzzles a lot of people. So I did a little bit of spelunking before I did this session, or before I put this session together, because I wanted to try to figure out, like, where does this come from? And for those of you who may not know, these gifts between employer provisions in the standards of conduct are based in statute, and the statute is 5 U.S.C. 7351. And so I started doing a little bit of research and had some help with that, doing some research on this. And I found out that actually the law has changed relatively little since it was first enacted back in February 1 of 1870. And it was enacted in 1870, and it was entitled An Act to Protect Officials in Government Employ. And I wasn't able to identify or to find out whether or not there was any particular scandal or any particular incident that necessarily prompted Congress to enact this legislation. But we were able to find a couple of newspaper articles that were actually quite revealing. And I'm going to read them in part to you now. I've excised, or I've taken a few pieces out of this rather lengthy, it was like an op-ed type of piece, which came from the Evening Telegraph. And it was published on January 14th of 1870, which was before the act itself was actually passed both houses of Congress. This was when the bill was pending before the Senate. And the Evening Telegraph said, "This bill is aimed at one of the standing nuisances of the day. Votive offerings to the vanity or venality of leading officials may be very acceptable to the recipients, but they at once impose an onerous tax upon their underpaid assistants and tend to the demoralization of public service. It goes on to say, and I found this kind of fascinating, it would be well if the example set by Congress were followed by states, cities, and corporations, for their employees are also frequently victimized. The gift enterprise business has been carried to a ludicrous and dangerous excess, and it should be stopped in every quarter. So I think that whether or not there was any particular scandal, it is very clear that there was a pattern of behavior or some sensibility in the public eye that government employees, lower paid government employees, were being strong-armed by their superiors to be providing gifts to their superiors. And I think if we understand also kind of the lay of the land in 1870, this was a time before the Pendleton Civil Service Reform Act. So this was back when basically, everything was based on political affiliation. It was a political spoils system. That's how you got a government job. There was no merit systems protection. There was no civil service per se. So it could be that the environment was such that it lent itself to much more onerous and much more egregious acts of coercion than we would ever experience today. But I think it gives you a sensibility about whence this law, why does it read the way it reads? And I wanted to show you that this is the language from the 1870 statute as it was then placed into Section 1784 of revised statutes. And it says, no officer, clerk, or employee of the United States government employee shall at any time solicit contributions from other officers, clerks, or employees in the government service for a gift or present to those in a superior official position. Well, there's our solicitation for contributions piece. We still have that. Nor shall any such officials or clerical superiors receive any gift or present offered or presented to them as a contribution from persons in government employ, notice this, receiving a less salary than themselves. So even back in 1870 when it was first enacted, this receiving piece reached not to just to superior subordinate relationships, but to the pay level of the two employees. And then finally, nor shall any officer or clerk make a donation as a gift or present to any official superior. So those three pieces that I just talked about that are in our current reg pretty much are wholesale sort of from the Act of 1870. This last piece, though, I think is really illuminating. Every person who violates this section shall be summarily discharged from the government employ. So Congress obviously took this very, very seriously, such that you could be summarily dismissed from government employment for a violation of this provision. To further sort of bolster, I think, an understanding of what the relevance of these provisions are and why they're important, I found a Supreme Court case from 1882. Now, this would have been some 12 years after the 1870 Act was enacted. Now, the case itself was not dealing with the constitutionality of the Act of 1870. It was dealing with sort of a related statute, which was a prohibition on requesting, giving, or receiving monies or properties or things of value for political purposes among government employees. And in this case, Chief Justice Waite, who argued for the constitutionality of that other provision, basically cited a whole litany of what he said were similar relevant provisions and was effectively making the same argument justifying those as he was doing for the particular act that was the subject of this particular court case. And it really reaches, I think, to the notion that this is about government as an employer maintaining certain rights with respect to managing the conduct of its employees. And he said in his argument, the evident purpose of Congress in all this class of enactments has been to promote efficiency and integrity in the discharge of official duties. So there we got efficiency of service. We still have that as sort of a concept of, in merit systems protection. And to maintain proper discipline in the public service. And on to the next slide, which is slide 17. A feeling of independence under the law conduces to faithful public service, and nothing tends more to take away this feeling than a dread of dismissal. If contributions from those in public employment may be solicited by others in official authority, it's easy to see that what begins as a request may end as a demand, and that a failure to meet the demand may be treated by those having the power of removal as a breach of some supposed duty. So that's, that's another rationale or another way of sort of getting our heads around like what the problem was and why it's still relevant today. Not meaning to belabor this, but I find all of this rather interesting, and I think it helps ground us. In 1899, now this is now 29 years after the enactment of the Act of 1870, the Washington Post had an op-ed that said, is this law honestly observed? So 29 years after the enactment, we still have people questioning whether or not this law is actually being abided by. It says, we often wonder whether this law is strictly observed in the spirit as well as in the letter by those to whom it explicitly refers. There are so many expedients by which a chief clerk or the head of a bureau or some other functionary of a humbler kind can extort tributes from his unhappy subordinates or punish them for ignoring his hints in that direction. There are so many pretexts upon which offerings can be invited, so many occasions when it may be made obvious that offerings will be acceptable, and there is so much human nature in the departments. And as a rule, the natural thing is the thing that happens. So again, clearly, notwithstanding this law, there was still perception that there were problems with people being forced to contribute to their superiors or provide gifts to their superiors. So in 1966 was when this law went into Title V of Chapter 73 of Title V, and it looks a lot more like it does the current day version. They changed the summarily being dismissed to shall be removed from the service. And then in the 1989 the 1989 ethics rule law. I'm forgetting what the name it is. Was when Congress basically gave OGE the authority to create exceptions. So up until 1989, this act was in place without the ability to have the exceptions that we currently have in the regulation. Ethics Reform Act, that's what I was trying to think of, sorry. And so now you can see that really since 1870 there's been very little change to the law, but OGE has had the ability to create some exceptions to sort of mitigate what otherwise can appear to be a rather draconian law. And I think that one of the things that we need to think about is a recognition of human nature. I think the Washington Post article was sort of trying to indicate that gifts between superiors and subordinates is almost invariably pernicious or malign. And I think what our exceptions to the rule and the fact that we were given the ability to create exceptions to the rule shows is it is human nature to give gifts. And we do have an environment in our workplaces where there is a level of collegiality. And human beings are motivated by a lot of good things sometimes when they want to give gifts, which include compassion, includes, celebratory sentiments. And so that's what our current regime is trying to recognize, I think, is sort of the good human nature part of human interactions and not strictly the more cynical or malign aspects of human nature. So having given you a little bit of a history lesson, maybe more of one than you actually had wanted, what I'd like to do now is to go into some of the exceptions and talk about them in terms of some actual concrete questions that we've gotten, some recurring questions that we've gotten about how those exceptions actually apply to the restrictions. So the first set of exceptions, as you're well aware, are ones they're titled general exceptions, but I like to call them sort of the occasional gifts exception. And if you look at 2635.304A, this is where the occasional gifts exceptions are found. I'll give you a minute to get there. If you have the compilation of the Code of Federal Regs, I'm on page 592. So the general exceptions are saying, on an occasional basis, which includes any occasion on which gifts are traditionally given or exchanged, the following may be given to an official superior or accepted from a subordinate or other employee receiving less pay. Okay, so we're saying on an occasional basis. It doesn't only have to be restricted to traditional gift-giving occasions like birthdays and holidays and Boss's Day, but it also includes those types of traditional gift-giving occasions. The first is items other than cash that are $10 or less, food and refreshments to be shared in the office among employees, personal hospitality that you would provide in your residence, and then if you are invited to someone's residence, it would include any item that's given in receipt of personal hospitality. And then we have the leave transfer for a program as being acknowledged in this exception. So I think it's best to sort of like ferret these things out mostly by actually looking at a few questions. So on slide 22, the first question and we get this a lot, is can employees go in together to buy a gift for a supervisor on a traditional occasion? So, for example, on Boss's Day or the boss or your supervisor's birthday, can employees contribute money toward a gift to their supervisor? And the quick answer to that is no. And the reason for that, at least in terms of the regulation, the way the regulation is written, is when we talk about being able to make a voluntary contribution, which is to say to be able to donate toward a gift to an official superior, the regulation stipulates only two circumstances in which employees can pass the hat to other employees, and employees can contribute to the hat being passed for a gift to an official superior. And that's on special and frequent occasions and for food and refreshments that are to be shared in the office. And by definition, anything that is happening on a traditional, occasional basis is not going to fit into one of those two opportunities where the regulation permits you to pass the hat and for employees to donate. So a group of employees could not go in together, for example, to buy a single $10 gift for their supervisor. Each individual employee can give the supervisor a gift up to the value of $10, but you could not collectively contribute toward a $10 gift, for example. And just for purposes of being able to explain that to yourself and to your employees, the issue here is frequency. The issue here is trying to maintain some sense of, I think, order in the office, and to limit the number of times that people can be hit up for contributions for various and sundry things. There are in every office some folks who are very, very generous, very big gift givers, and that there's no opportunity that they like to allow pass that could be an opportunity for a gift giving that they don't want to take advantage of. And I don't mean any bad motivations, but there are folks who are much more inclined to give gifts than there are others. And I think that this provision is simply designed to minimize the number of times that employees can be solicited for a gift for an official superior. The second question I have here is, how about splitting the cost of the supervisor's lunch? Like if we wanted to take our boss out for lunch, or we somehow wanted to buy food for our supervisor, would we be able to split the cost of the supervisor's lunch? I think there are a couple of things that you have to ask yourself here first. The first question that I would want to know is, what is the occasion that's being celebrated? If it constitutes some special and frequent occasion, then you can avail yourself of that, and you could make donations toward the lunch, and you could split the cost of the lunch because it's a special and frequent occasion. If it's not a special or frequent occasion, then my question would be, well, where is the lunch taking place? If the lunch is outside of the building in a restaurant, then we would say no, that you wouldn't be able to just split the cost of the supervisor's lunch among whomever decided to go out with the supervisor to lunch. If it's in the office, and it's going to be, then I would argue then maybe you could, because then we're looking at food and refreshments to be shared in the office among several employees. So instead of taking the supervisor out for lunch, you could, for example, order food in, and you could split the cost of the food by ordering the food in. because we have said that food and refreshments to be shared in the office does not have to be in kind, that you can collect donations to purchase food and refreshments to be shared in the office. So it's going to depend. The answer to question 2 is going to depend on what the occasion is that you're celebrating, and whether the lunch is going to take place outside of the office or the lunch is going to take place inside the office. On the next slide, slide 23, the third question, and we get this one an awful lot, which is, are gift cards allowed? And I know that the concern here is that under the $10 de minimis rule, it says items other than cash. So there's always this big question mark around, is a gift card a gift or is a gift card cash? And OGE just recently issued a legal advisory talking about this. We addressed it in the context of the $20 de minimis gift exception for gifts from outside sources. But we also said in that legal advisory that our analysis of gift cards for that purpose could also extend to the gifts between employees provisions. And effectively what we said in that LA is it depends on what the nature of the card is. It depends on what the type of gift card is. Because they do come in various guises. So a general use prepaid card could not be accepted under the $20 de minimis exception, regardless of its well, in our case, under the $10 de minimis exemption, regardless of their value. Because, and by that we're talking about things that are issued by major sort of credit card companies like Visa, MasterCard, and things of that nature. Because they are effectively the same as cash. They can be used anywhere that will effectively accept a credit card. So those would not be allowed under the $10 gift rule because they are considered to be cash equivalents. Store gift cards could be accepted because they are limited to purchases from a particular establishment. So a store gift card would be permissible under the $10 de minimis exception. Likewise, a mall gift card, we have said that's tantamount to a specific store gift card because you're still limited as to where you can purchase items with that card. And then finally we said gifts that are co-branded with the logo of a payment network and the logo of a merchant or affiliated group of merchants are general use prepaid cards and not store gift cards. And I don't know how often we see those, but my understanding is that they might have the store logo on them, but that they also then have like a Visa, MasterCard or something other sort of logo to them. And it's an indicator that they can be used in other than just the store whose logo is represented on it. Next week for the Advanced Practitioner Series, they're going to be discussing this in a little bit more detail, but I just wanted to let you all know, and particularly for those of you who may not be able to make the one next week, that this same thing, these same provisions, this same analysis applies to the $10 de minimis gift exception in the gifts between employees provisions. The next question is, can superiors give subordinates gifts and may subordinates accept them? There is nothing in the gifts between employees provisions that says that a superior may not give a gift to a subordinate or that a subordinate may not accept a gift from an official superior. So there's nothing in the gifts rules that would prohibit this. I think the only possible, and I don't even know if, I'm assuming this is theoretically possible, the only thing that time that might not be true is if for whatever reason the subordinate makes more money than the superior. And I guess that could happen if you have a GS-15 employee who's supervising another GS-15 employee. So that's one of the squirrely things about that second provision on receiving is it doesn't talk about superior subordinate necessarily. It talks about whether or not the person who's giving you the gift receives less pay than you. So generally speaking, the answer to this question is yes, superiors can give subordinates gifts, and subordinates may accept them. as I said, unless there's a strange situation where the subordinate actually makes more than the superior. The next question, this one we get every year, which has to do with white elephant. They come in they call them by different things, but I think everybody understands what we mean by a white elephant gift exchange, where everybody brings in a wrapped gift and then you sort of pick numbers and you randomly are allowed to choose a gift, and then it's a little game that I think a lot of folks play at holiday parties. And so the question then becomes, is there any restriction on all employees being able to participate in a white elephant gift exchange? And the answer to that question is, yeah, there is a way that all employees can engage in that kind of a gift exchange, and it's basically to make sure that all of the gifts that are contributed are worth no more than $10. Because it's a traditional occasion. If we're going to have superiors and subordinates participating in it, or people making more money and less money participating in it, notwithstanding that it's anonymous, I think just out of an abundance of caution it is, and I think just to make sure that it's fully within the four corners of the gifts between employees restrictions, we've advised folks that all employees should be instructed to purchase a gift that would be worth no more than $10 in value, and then you're safe. So food and refreshments in the office. This is one of the other exceptions to the under the occasional gift giving exceptions. And the question there was, can all employees share in the food at an office potluck? And the answer to that, again, is yes. Even if not everybody contributes, all employees are allowed to share in the food that is offered at an office potluck. And again, I want to remind you that can be a potluck where everybody brings in food. It can also be if a portion of the potluck is that donations were made to purchase other food, and from some sort of establishment, or to have the event catered. In all of those instances where it's food and refreshments that are being shared, all employees are allowed to share in that without it being considered a prohibited gift to anyone. There was a question that did come up with respect to that, and I don't know that OG's ever made a formal policy call on it, but I think it's kind of a commonsensical approach to this, which is, what about plates and forks and spoons and utensils that, because it would be kind of silly and foolish, I think, to say, oh, well, everybody can share in the food, but everybody's got to bring their own plate, spoon, and fork, because otherwise they're engaging in receiving a gift because somebody contributed that. So I would argue that in the donations for food and refreshments to be shared in the office, any monies that were collected for that purpose could also be used toward paper plates and forks and napkins and sundries like that.
Cheryl, we have a question that just came in.
Okay.
Can a landmark birthday such as the 50th birthday ever be considered a special and frequent occasion rather than a traditional occasional basis?
That's such a good question, and I wish my answer, on some level, I wish my answer to you was going to be different, because I do understand the sensibilities about that, and I think as a matter of custom, we do recognize certain regularly occurring events at certain milestones as having special status. But this is a question that OG answered quite some time ago, and that was no, that notwithstanding that 50 years may seem like a special milestone, we don't consider it to be a special and frequent occasion. It is just one of many regularly occurring occasions, and we've been disinclined to, because we don't want to have to get into then the idea of, well, when is a birthday a special and frequent occasion, and when is it just a regularly occurring occasion. So I'm sorry to say that the answer to your question is that no, it cannot be considered a special and frequent occasion. Okay. So our next set of exceptions, and we call them an exception, but it's really, and I think it is an exception because it's reaching to when can employees solicit and when can employees donate to a gift to an official superior. And the regulations themselves address two, as I said before, two circumstances where you may ask for and employees may contribute. And that's on special and frequent occasions of personal significance. And the second is for food and refreshments to be shared in the office by a group of employees. So let's talk about a few common questions that we get involving voluntary contributions. The first question is, and for folks on the phone, I'm at slide 29, I'm sorry. The first question is, who may solicit and collect monetary contributions? And this is really an outstanding question, and it can be sort of a problematic thing because the regulation is really kind of silent on that. The regulation doesn't really say who's appropriate to do so and who isn't. But I think as a general proposition, I have always counseled ethics officials that to the greatest extent possible, supervisors never be allowed to solicit monies from employees simply because, again, of that kind of notion of the inherent coercive nature of that kind of a solicitation. And the fact that these solicitations, these contributions are meant to be voluntary, I think it's very hard to ensure that contributions are voluntary when subordinates are having that solicitation come from a superior. So I think to the greatest extent possible, superiors should not be able to make those solicitations or collect the monetary contributions that would be donated in that kind of an agency-wide solicitation. And that's kind of just as a general proposition. I think it's always best, and I would say even among senior managers, if senior managers are doing something among themselves, I still think it would be most advisable to have an executive assistant or someone like that issue the solicitation, and if monies are going to be collected, collect the monies, just to avoid any sensibility that there's any sense of coercion that's involved in that solicitation or collection. The next question is, what amount is nominal? And we don't, as you've probably seen in the regulation, we don't offer any kind of a dollar value for, nominal amount. We don't even really particularly define it. I think what we try to do throughout our examples are to show in various guises what might reasonably be considered to be a nominal amount. I think the difficulty with this particular one is that it really varies almost from person to person. And it sometimes is going to vary based upon how much money the employee makes, or even just their general disposition. I mean, just how much you make isn't necessarily always just positive, but, because sometimes even people just have just different dispositions about, their level of generosity. So it's really hard to give you even a general sort of line to determine what necessarily is uniformly going to be considered nominal. I think that that for most people, $5, $10, $15, $20 would be considered to be nominal. But there might be some other circumstances where, given the nature of the special and frequent occasion, let's say that you had someone in the office who suffered some sort of really tragic event, like a fire in their home or something, that was quite devastating. Folks might feel that a nominal amount in that case was larger than $5 or $10. So I think it's a matter. I think it's more a matter of sort of trusting people's own sensibilities about what constitutes nominal, and the other limitations on agency's ability to, or employees' ability to suggest amounts, The fact that whenever you do ask for voluntary contributions, it's supposed to be accompanied by a statement that employees are free to contribute less or nothing at all. So I think all of those sensibilities and those articulations of, you're not required to contribute, and if you do, it's whatever you feel like contributing, then really just kind of puts it back on the employee, him or herself, to give what they feel is comfortable. And I know that's not a terribly satisfying answer, but I think OGE was wise when we didn't attempt to put a dollar value on what's nominal, because I do think it's very subjective, and I think it very much depends on the people involved and the events surrounding the solicitation. And that sort of leads into the third question, which is, can a dollar amount be suggested? In the regulation itself, in the definition of voluntary contribution, I'd like everybody to take a look at that, because there are two pieces to that I'm going to be talking about both pieces here in succession. And it's at 2635.303F is where we define voluntary contribution. And we say it means a contribution given freely without pressure or coercion. A contribution is not voluntary unless it is made in an amount determined by the contributing employee. Now, I want you to stop there for a minute, because the next part that's in there I'm going to come back to with the next set of questions. So I'm going to sort of skip over this middle piece in here, and I'm going to ask you to look down further in that paragraph to where you have the next word where except appears again is capitalized. Okay? So up to this point we've been saying it's a contribution is not voluntary unless it is made in an amount determined by the contributing employee. Now we're down at this next sentence, and it says, except in the case of contributions for a gift included in the cost of a luncheon, reception, or similar event, which is what I'm going to talk about in a minute, a statement that an employee may choose to contribute less or not at all shall accompany any recommendation of an amount to be contributed for a gift to an official superior. So again, we say right in the reg, right in the definition of voluntary contribution, that this has really got to be the spirit that surrounds any solicitation, which is that contributions should be nominal, they should be given voluntarily, the individual employee gets to choose what that nominal amount looks like and is comfortable for them, and they should always be allowed, or they should always be made to understand that a solicitation is not a demand, and that they are free to give less or to not contribute at all. And I really think that that sort of inculcating that kind of spirit in any solicitation is probably the most important thing that can be done to mitigate any sense of pressure or coercion or any concerns about whether amounts are nominal, et cetera, that might surround a solicitation and contributions to a gift. So the third thing, the last sort of piece I wanted to look at in terms of the exceptions was the special and frequent occasions exception. I said I'm going to come back to that voluntary contribution, that middle piece of the definition, and I am going to do that in just a second. But I want us to take a look at the special and frequent occasions exception itself, which is at 2635.304B. Give you a minute to get there. Okay, and if you look at that, it says, a gift appropriate to the occasion may be given to an official superior or accepted from a subordinate or other employee receiving less pay in recognition of infrequently occurring occasions of personal significance, such as marriage, illness, or the birth or adoption of a child, or upon occasions that terminate a subordinate official superior relationship, such as a retirement, resignation, or transfer. And there's just a couple of things I want to highlight for you there that I'm going to sort of hone in on a little bit more when we start talking about the questions, but I like to just make sure that you sort of like keep them in your head with respect to the actual language of the exception, which is special and frequent occasions the gift just has to be appropriate to the occasion. So unlike the occasional gift exceptions where there were some stipulations about either the value or the type of thing that you could give or receive, under special and frequent occasions, we haven't determined what that gift can look like and even necessarily how much that gift can be worth. All we say in here is that the gift has to be appropriate to the occasion. The other thing I wanted to point out is the paragraph 1 there, B1. It's talking about infrequently occurring occasions of personal significance. So whenever you're looking at occasions to determine if they meet that qualification, you really have to be looking at things that are personal in nature in order for you to be able to use B1. And when we get into the questions here, I think we're going to flesh that out a little bit more. But as you can see from my visuals on the screen there, retirement and weddings and baby showers, those are all the things we commonly think of. But, you know, folks have some tragic things happen in their lives too, and those can qualify as special and frequent occasions of personal significance as well. So let's look at the first question that we have, and this is going to pull us back into our definition of voluntary contribution. It says, how do voluntary contributions work when there is a luncheon or a reception? And I think we've all seen these happen in the context particularly of retirements and things like that. And here's where I want to pull you back into the definition of voluntary contribution, because I think this piece causes folks an awful lot of confusion. So we go back to 2635.303F. And we get to that. Contribution is not voluntary unless it is made in an amount determined by the contributing employee. And then it says, except that where an amount for a gift is included in the cost for a luncheon, reception, or similar event, an employee who freely chooses to pay a proportionate share of the total cost in order to attend will be deemed to have made a voluntary contribution. Okay? So let's look at that a little bit more closely. So whenever you're having a luncheon or a reception or some sort of similar event, and there is a cost associated with that. So you have a per head cost. So if you're going out for lunch and you're all going to chip in for the person's lunch, it's understood in advance that the cost per person is going to be not only the lunch that you pay for, but a proportionate share of your supervisor's, the cost of your supervisor's lunch, okay? That would be one circumstance. But it also contemplates if you're holding like a reception someplace and there's going to be a cost per person involved with that. What this is saying is if an employee elects to attend that reception and there's a per person cost to attend that reception, if you tag on an additional amount for a gift that's included in that total cost, then by agreeing to pay the proportionate cost for the reception, the employee is sort of having made a voluntary contribution. So we have two different examples that sort of illustrate what I just talked about, what I was trying to give you by way of explanation. And the first one is in that example 1, which is right under the definition. And that's where example 1 says, a supervisory employee of AID has just been reassigned from Washington to Kabul, Afghanistan. There's a farewell party and 12 of her subordinates are taking her out to lunch. I don't know whether or not this restaurant even exists any longer, but anyway, it's understood that each will pay for his own meal and that the cost of the supervisor's lunch will be divided equally among the 12, even though the amount they will contribute is not determined until the supervisor orders lunch. The contribution made by those who choose to participate in the farewell lunch is voluntary. Okay, so that was along the lines of the first example that I gave you. The second example I gave you actually comes under where the exception for voluntary contributions resides, which is at 304C. And if you go to 304C, the first example says, to mark the occasion of his retirement, members of the immediate staff of the Undersecretary of the Army would like to give him a party and provide him with a gift certificate. They may distribute an announcement of the party and include a nominal amount for retirement gift in the fee for the party. So again, it's another one of these situations where there's a cost-sharing arrangement, and there's going to be a per-person cost to attend the event. You can include in that cost of attendance, and in this case they said a nominal amount for an actual gift over and above just the gift of the reception or the party. So that's how that. Now, one thing I want you all to be really mindful of, and this is something that I think happens inadvertently, certainly not by design. It's one thing to solicit contributions toward a gift that's over and above the cost of attendance for fellow federal employees. You may not do the same if you are extending invitations to non-federal sources, particularly those who happen to be prohibited sources. So I would advise you to be careful when these kind of parties are being planned, for whomever's going out with a solicitation, to remind them that you cannot be soliciting gifts from prohibited sources. So to the extent that there may be prohibited sources who are being invited to these receptions, make sure that they get carved out of any solicitation for. Now, it's okay to ask them to pay their proportionate cost of the event. So if there's like a per head cost for the reception, then they're just paying the market value of what it's costing you to put on the party. But what I'm talking about is that addendum, that additional nominal amount for an actual gift to be given to the employee. Just be careful not to be soliciting those from prohibited sources. Okay, so I'm on slide 32. The next question is cash ever allowed as a gift, or must it always be an item that has been purchased? Now, we know under the $10 de minimis gift rule, which is under the occasional basis provisions, gifts of cash are not acceptable. However, under the special and frequent occasion exception, if you remember, I went back and said it's a gift that's appropriate to the occasion. And there are any number of occasions where a gift of cash is or could be appropriate. So there is no restriction on the nature of the gift that can be given in a special and frequent occasion. Again, it's simply a matter of whether or not that gift is appropriate. Now, I'm pretty sure that for folks at DoD, the JER, I think, has some additional policy prescriptions or regulatory prescriptions with respect to gifts between employees. But for rank and file government employees who are not subject to any other set of additional policies or restrictions, really cash is okay. And again, there's no stipulation as to what value of the gift is necessarily appropriate. We just say that the gift has to be appropriate to the occasion. The next question is, can employees collect contributions for a gift to a coworker in recognition of her promotion to a higher graded position? And this one's a little tricky. This one's, again, I think is going to depend on a couple of different things. Number one, what is the position to which the coworker is being promoted? Is it just a higher paid position? Or is it going to be one that actually makes the coworker a superior to their fellow coworkers? So now we have a superior-subordinate relationship. If it's a superior-subordinate relationship, if an employee is promoted into a position that now makes the employee the superior of her coworkers, then a promotion to that position would not be considered a special and frequent occasion. And let me explain that to you how that works in the context of special and frequent occasion exception. As I told you before, in order to use B1, it has to be a special and frequent occasion of personal significance. And OGE has said that promotions and things like that are things not of personal significance, but of professional significance. And we deal with that whole professional piece in part 2 of the special and frequent occasions, where we're saying, okay, so if you've got a professional circumstance like promotions and reassignments and retirements, then we're talking about it has to terminate, the occasion has to terminate a subordinate official-superior relationship in order for you to be able to use the special and frequent occasion exception, okay? So if this person is being put into a superior position, the promotion does not constitute a special and frequent occasion of personal significance, and they could not make contributions to a gift to their newly promoted coworker. But what about if the person's just being promoted to a higher paid position and there is no superior subordinate relationship? Well, in that event, I think we would say, because there's no superior subordinate relationship, it's the employee would be able to accept gifts from employees making less pay. No, wait a minute. We would not be concerned about the termination of the superior subordinate official relationship because there isn't one. The employees, I believe, would be able to contribute to the promotion of their coworker, because it's not something that you have to worry about the termination of the superior subordinate relationship. In the next case, this one comes up a lot, and I think what makes this one troubling, or what makes this one a little dicey, I think, is because we bump up against the combined federal campaign provisions when we start dealing with collections in the context of natural disasters. And we certainly know that it's been a very active natural disaster season for a lot of the country, and we know that a lot of folks have coworkers who are in affected areas, and out of compassion, we like to help out our federal feds. So in the case of a natural disaster, when is it okay to collect voluntary contributions for fellow government employees? And this is one of those things where it really depends on for whom the solicitations and donations are being made. If you're soliciting voluntary contributions for gifts that will be given directly to employees or to employees' families, then you're definitely within the ambit of the gifts between employees rules, and you really don't have to worry about CFC. So as long as when your solicitation or your collection is going to be given to government employees individually or to their families, you are squarely within the gifts between employees rules, and you just have to abide by those gifts between employees rules. And we have the special and frequent occasion exception, which allows for contributions of nominal amounts. And a natural disaster would certainly be a special and frequent occasion. Where you have to start being a little bit more mindful of CFC is when there are solicitations for contributions that will be made to charitable organizations rather than directly to government employees themselves. And it's in that circumstance where you have to abide by the gifts between employees rules, because that would be considered an indirect gift under the gifts between employees rules. But you would still have to make sure that you weren't bumping up against the CFC fundraising rules. Now, OGE does not have cognizance over the CFC fundraising rules, so I raise it to your attention just so that you're careful about it if and or when these things occur. And that's, if you look at Part 950, the definition of fundraising for purposes of CFC is whenever there's any solicitation of funds from federal employees in the federal workplace on behalf of charitable organizations, that's by definition fundraising under the CFC rules. Now, I don't know whether OPM would necessarily opine one way or the other as to whether a collection in your office would or wouldn't implicate the CFC fundraising rules. I do know the OPM is very sensitive when it comes to natural disasters about making certain that if people want to do special solicitations, they have a whole specific set of procedures and things that they have agencies go through when agencies want to do special solicitations for natural disasters. So I would just caution you that if you want to do something like that in response to a natural disaster, that it's probably best if you limit it to solicitations for gifts to be given directly to employees or their families. And if you want to do anything other than that, then I would definitely clear it with OPM before you did something like that.
Cheryl, we have a pretty detailed question on this.
Okay.
It is, if an employee dies and an employee solicits for flowers for the funeral and or solicits employees for plane ticket for family member to attend funeral and wants to use email, does Subpart C apply, or do we look to 950 Subpart G and supplemental rules?
So the question is, can you read that to me again, Kenesha?
Sure.
I'm trying. There are a lot of
Sure.
facts in there. Okay.
Sure. An employee dies,
Okay.
and one, employee solicits for flowers for funeral, and or two, the employee solicits employees for plane ticket for family member to attend the funeral.
Mm-hmm.
So I'm assuming that the employee's family member passed away,
Mm-hmm.
and they want to send the employee to the funeral.
Right.
And they want to use U.S. email. I'm not sure about that. Does Subpart C apply, or do we look to 950 Subpart G and supplemental rules?
I think I would argue that I think for at least in the first instance, when you're talking about solicitation for flowers or even a solicitation for a monetary contribution to the family, or that would to help defray costs or whatever, I think those sorts of things should fall within the gifts between. If you're going to do a solicitation of that nature, I think that falls within the gifts between employees. I don't think. I mean, I would not argue that a deceased employee no longer is an employee and therefore is not subject to that whatever solicitation is done shouldn't fall within the ambit of Subpart C. I think that would be silly. But so my argument would be, and I know that we even at OG have done solicitations for contributions to families in the event of a death of a coworker. So I think the solicitation for that kind of a gift, whether it be, again, for flowers or for defray costs or to give a contribution to the family in some way, would all fall within the ambit of the gifts between employees rules. Like I said, the only time I think 950 would come into play is if the donation was going to be given to a charitable organization. And even then, I don't know. In the case of a death of an employee, I really don't know, and it would be something that you'd have to talk to OPM about to see if they felt that kind of a solicitation under those circumstances implicated the CFC fundraising rules. In terms of being able to use your .gov email, I guess is the question. I don't think that OG has ever opined that use of the .gov email is an inappropriate use of government resources in the event of the death of a coworker. I know that we use our .gov email when we have wedding parties for people who are getting married and parties for people who are having. So anything that falls within the ambit of the special or frequent occasions and things like that, we would probably treat it, I guess, if we treat it as an unauthorized use of government equipment, it would certainly fall within de minimis uses of government equipment and time. So I don't see any reason why employees in an organization would not be able to do that kind of thing using their .gov email. I hope that answers your question. If not, then let us know on the Hangout if that did not answer your question. And thank you for that. It was a great question. And so the last sort of area I wanted to talk about are kind of really sort of your non-traditional gifts or non-customary gifts. And it's just something I think for everyone to sort of think about. The first question was, is a loan to a superior considered a gift? And I think by any definition of gift, a loan to a superior would definitely be considered to be a gift. It's something having monetary value. And for purposes of Subpart C, we rely on the definitions of gifts that are in Subpart B. And if you look at the definition of gift in the gifts from outside sources, it's everything in the kitchen sink for the most part. It's anything having monetary value. And so a loan would be considered a gift to a superior and would have to fall within all of the provisions of the gifts between employees. And I would argue that it's probably never advisable for a subordinate employee to give a loan to an official superior, whether it is, completely with acquiescence or above board. I think it's a bad idea to begin with. But there's also the additional sort of 208 considerations I think that you have to be aware of, that once you have 208 and 502 considerations, because once you have a loan between the superior and the subordinate, there is at least an informal contract or business relationship between them, because the presumption is that the loan should be repaid. So at the very least you have a covered relationship, but then on top of it you do have some 208 implications, because depending upon the nature of that loan or whatever, the superior doing anything that could in any way result in the promotion of that subordinate, you just don't want to get into colorable, 208 interests where the superior, the subordinate, are engaging in transactions that wind up giving them a financial relationship that then makes it difficult, if not impossible, for the superior to actually supervise the subordinate. And you may think that that's a bit of a stretch, but we do have in our prosecution survey, in our, I think it's our 2014 prosecution survey, we have a situation where it went the other way. It was a manager who gave money to a subordinate. And the superior had taken out an advance on their credit card to give money to a subordinate who was having some legal trouble. And then subsequent to that sort of personal loan or that just gift of cash to the subordinate, that supervisor then tried to intervene in some disciplinary actions that the agency was planning to take against the subordinate, and rather significantly so. And ultimately the Department of Justice pursued it, and they entered a plea agreement where the gentleman in question pled guilty to a felony violation of 208A, and he was sentenced to pay. He paid a $2,000 fine, but clearly that had real 208 implications when you had money exchanging hands between a superior and a subordinate. And like I said, that went in the opposite direction with the manager giving the subordinate, but there are still these kinds of implications that are involved anytime you have superiors and subordinates engaging in monetary transactions, and they're just a bad idea, period. And then the final question I have here are, may supervisors ask subordinates to run personal errands or perform personal work for them? I don't know how often this happens, but we have contemplated that clearly this is or can be a gift to an official superior, because a superior can't ask a subordinate as part of their official duties to perform personal tasks, because then that's basically asking them to engage in activity it's a misuse of that subordinate's time, and it runs afoul of the misuse of position in the standards of conduct. And even on off-duty hours, you're also dealing with a prohibited gift, because if you're asking a subordinate employee to perform personal tasks for you off-duty, then unless you're remunerating them for it, unless you're paying them for their personal time, the subordinate employee is in effect giving a gift to the official superior. And we do state that explicitly in Subpart G when we talk about misuse of position. And when we talk about use of official time, we talk about use of a subordinate's time. And we say an employee shall not encourage, direct, or coerce or request a subordinate to use official time to perform activities other than those required in the performance of official duties or authorized in accordance with law or regulation. And then in our example below that, we give an example of an employee at HUD who asked his secretary to type his personal correspondence during duty hours, and then Further, directing or coercing a subordinate to perform such activities during non-duty hours constitutes an improper use of public office for private gain. And we go on to say, where the arrangement is entirely voluntary and appropriate compensation is paid, the secretary may type the correspondence at home on her own time. Where the compensation is not adequate, however, the arrangement would involve a gift to the superior in violation of the standards in Subpart C of this part. So we speak about this explicitly in the misuse of position section, that anytime, supervisors are asking their subordinates to do personal favors for them and are not remunerating them for the use of their personal time, they're not only running afoul of the misuse of position provisions, but they're also potentially running afoul of the gifts between employees provisions. And with that, that's all I have for us today. I don't know if you found the questions to be adequately... Oh, we've got some questions on the Hangout.
Yep, we have several questions that come in.
Cool.
Okay, the first one is, does the prohibition on gifts to supervisors apply to first-line supervisors only, or all persons in the employee's chain of command?
That is an excellent question. And the simple and the quick answer to that is, it's everybody in the chain of command. Whatever your stovepipe of chain of command is, it's not just your immediate supervisor, it's anybody who's the superior of your superior throughout the entire chain of command. And you actually find that in the definition of official superior at 303D, but just so that it's abundantly clear, yes, it's everybody who's in the employee's chain of command.
Okay, great. Okay, and the next one is, does Section 209 bar federal employees from accepting gifts that would otherwise qualify for a gift exception when they are offered by the donor in recognition of specific work performed by a federal employee?
I think I'm getting the gist of the question, and this would come up in the context of, if, let's say, someone is giving a gift to another federal employee for services performed as a federal employee. And I think that we have said, whether we've put it in writing or not, that any time, and it's typically going to come up, I think, in a context where a superior is giving a subordinate monies in recognition of performance of duties. And I think that we have said that that is a colorable 209 problem, because, and it doesn't matter how well intended it was, if the monies that you're giving the employee are in recognition of services that they've provided, that money in exchange for their federal services is not a gift, it's compensation, or could be deemed to be compensation. And it may run afoul of 209, because for those of you, all of you should be aware, 209 basically is a supplementation of salary prohibition, which says, in effect, that no one but the United States government should be paying government employees for the performance of government duties. And if an employee in their personal capacity is contributing to the compensation of another federal employee for the performance of their services, I think OGE has said that that's a colorable 209 problem. That's a great question.
Okay, and the next one is example 2 in 2635.204 indicates an employee may keep a gift valued at less than $20 after giving a speech in his official capacity. Wouldn't this gift also be prohibited?
So we're in the gifts from outside sources. People are doing the rope-a-dope on me here and pulling me into other provisions here. So I'm sorry. So it's example 2. Is that what was said?
Yes, example 2.
Okay. So this is okay. So we've got a Department of Mapping agency employee was invited by an association of cartographers to speak about his agency's role in the evolution of missile technology. At the conclusion of his speech, the association presents the employee a framed map with a market value of $18 and a book about the history of cartography with a market value of $15. The employee may accept the map or the book, but not both, since the aggregate value of these two tangible items exceeds $20. So I guess the person is asking is, since this is clearly, I think the argument here is that this is not, this is not compensation in exchange for services This is a gift which is sort of a thank you for having come to visit us, but it's not precisely compensation in exchange for services. And this does get to, this gets to a sticky area of law, which is, when is something in consideration for services such that it should be treated as being tantamount to compensation, and when is it sort of a gratuitous thing that is not clearly tied to the performance of services such that it shouldn't be deemed compensation. And I think in OGE's gift rules, what we have established through some of the exceptions, and by, for example, under the $20 gift rule, you're not, because we don't want to muddy the waters with that sort of thing, where anytime you're giving somebody cash, I think it becomes more difficult to discern when you're actually compensating someone for services as opposed to providing a gratuity that is not intended to be compensatory. But so that is how I would distinguish that question from the situation where a supervisor is giving cash to an employee that is explicitly for the performance of duties, and it's in recognition of those explicit duties. And because it would be, in that situation, it would be cash. I think that's the type of circumstance where we're talking about bleeding over into, or being much closer to, or in fact tripping right into a compensatory 209 concern.
Okay, that looks like that's all we have on the Hangout.
Do we have anyone on the phone who has any questions?
There are no questions on the phone line at this time.
Okay. Well, I want to thank everyone for joining us this afternoon. I hope this was, at least in part, satisfying. I know there's been a lot of people waiting for us to finally do something on gifts between employees, and hopefully this fit the bill. And if not, please do let me know, and I'm sure you will. But we look forward to having you with us, all of you, with us again next week for the Advanced Practitioner Series.
Yes, and you will be receiving an evaluation from me shortly. And we appreciate your time. Thank you.
Thanks very much, and have a great afternoon.
This concludes today's conference. Thank you for your attendance. You may disconnect.